Legal Liability Part 2. We're going to talk about common law and words, breach of contract, and tort. A breach of contract implies there's a contract between the two parties that was breached. A tort is a wrongful act, damage, or injury done willfully, negligently, but not involving a breach of contract. So damage, somebody was harmed by a wrongful act, and it doesn't involve a contract. This is what third-party investors are going to look to. We would expect the audit client to file a breach of contract against the auditor. We would expect third-party investors to file a tort claim against the auditor. Tort claims, common law, one of the dirty words that comes up are punitive damages. So I lost a $10,000 investment, but my wife left me and she took my pickup truck and the dog. So I'm going to sue for the $10,000 loss plus punitive damages for the loss of my dog and the truck. Sounds like a country song, doesn't it? Joint and several liability, proportionate liability. The securities laws were originally written that the auditor was jointly and severally liable for the financial statements. That's since been changed, but think about that. So joint and several means that the auditor can be held fully liable regardless of their participation. Proportionate liability implies that the auditor should only be liable for their proportion of the harm. So if the jury were to find that the management was 90% responsible and the auditor was 10% responsible, then if it was $1 million lawsuit, the auditor would only be liable for 10% of that $1 million loss. Standard of care, like I said, I don't know whether that's a true word or not, but ordinary negligence, then we have gross negligence, recklessness, constructive fraud. I lump those all together. They're worse than ordinary negligence, and then we have fraud. The book has an excellent table. I don't know what page it's on, where they talk about absence. Ordinary negligence is absence of reasonable care that would be expected. What would we expect another competent auditor to do in a similar situation? Gross negligence is a lack of even slight care. Constructive fraud is worse than, well, I don't know. The auditor knew the audit was not adequately done, but they still issued an opinion. They didn't have any intent or knowledge of deceiving users, but they knew the financial statement audit was not adequate, but they went ahead and issued the financial statements. The fraud or problem could not have occurred without the auditor being complicit. Fraud is intentional. This is what I call standard of care. What standard of care is unacceptable for a professional? I don't know the answer. I always ask that question in class and we discuss, and students are frustrated that I don't really have an answer. Can we expect a doctor to never make mistakes? No, they're human, and doctors can make mistakes. Is it acceptable if the doctor makes a mistake on somebody in my family? No, it's acceptable if it's somebody in your family, but not my family. I remember when I taught for KPMG, the lady that was in charge, the partner was in charge, was a fantastic lady. She said something that did trouble me, and she said, auditing's not rocket science. People's lives don't depend on it. I take a little bit of exception. I think of Enron. In the spring of the year, many Enron employees were millionaires from their 401k plans. By November, those employees were broke. They lost everything they had in their 401k. Now, I've often thought, what would it be like to be 50 or 60 years old and have to start over again? That would be tough. I'm sure there were many suicides and bankruptcies because of Enron. So, no, it's not brain surgery, but it does significantly affect people's lives. So I want you to take it very, very serious, just as you would expect your surgeon to take your operation seriously. What standard of care is unacceptable if the plaintiffs have privity of contract? So there's a contract. If there's a contract, I'm going to say negligence, but the reality is it doesn't even have to be negligent. You just did not fulfill the contract for whatever reason. If I hired you to paint my house red, and I come home and you painted my house green, if I can show that I had a contract for you to paint the house red, then you've breached the contract and I'm entitled to compensation. The book talks about the auditor's defense under common law tort. And the auditor's going to show they did not have a duty. They're going to show that their performance was non-negligent. They're going to show there was no causal connection. That's fine. For me, it makes more sense to look at it the other way. What does the plaintiff have to prove under common law tort? And they have to prove there was a loss. They have to prove the auditor had a duty to perform, that the auditor breached that duty, the auditor was negligent, and that the financial statements were the cause of the loss. Okay, we're not going to worry about contributory negligence. I'll explain why on the next slide. So the investor suffered a loss. No loss, no common law tort. Remember the definition talked about damage. The auditor had a duty to perform. The auditor was paid to perform on a gas level audit, general accepted auditing standard. The auditor was negligent. They did not exercise due professional care. The causal connection, the loss was caused by reliance on audited financial statements which were materially misstated. The reason we don't worry about contributory negligence in this case is because the investors did not produce the financial statements. Okay, so it's hard to imagine the investor contributing to the problem. So we're not going to worry much about contributory negligence. Remember, there's additional presentations for this material.